We finally got more information about that super shady subpoena, and Ron is back to
Blake Lively's legal team allegedly pulled off a shocking brazen maneuver, weaponizing an 11-year dormant company called Vans & Inc. as a phantom weapon in a meticulously planned legal ambush against Justin Baldoni. This was no ordinary lawsuit, it was a calculated charade, a straw lawsuit filed against unnamed John Does, designed purely to bypass ethical boundaries and illicitly gain subpoena power. The alleged intention was to secretly extract sensitive private communications, creating a narrative that could then be strategically leaked and amplified for public consumption. This audacious gambit, now exposed, points to a calculated abuse of process, where the judicial system itself was allegedly treated as a personal instrument for a high-stakes reputation demolition. The layers of deception are finally peeling back, revealing a chillingly corporate approach to personal vendettas.
Hence, these unnamed individuals were dropped or just disappeared.
The saga began with a mysterious filing on September 27, 2024 in a New York court, Vans & Inc. versus John Does 1-10. This wasn't just vague, it was literally faceless, without a single named defendant, purpose, or real point. Legal experts immediately flagged it as highly suspicious, noting that legitimate complaints are not filed against anonymous parties unless there's a clear stated reason for protecting their identity. This extreme anonymity raised immediate red flags, hinting that the lawsuit's true objective lay far beyond traditional legal recourse. It seemed less like seeking justice and more like a carefully constructed framework for something else entirely, leaving many wondering about the actual target hidden within the John Does. The stage was set for an unconventional legal play.
now we're seeing Blake actually do it with
The stunning truth about Vans & Inc. quickly emerged. This mysterious entity was owned and operated by none other than Blake Lively, under her married name, Blake Reynolds. She wasn't just a plaintiff in this twisted courtroom cosplay. She reportedly served as the CEO, secretary, and CFO of Vans & Incorporated. This wasn't a legitimate business seeking redress. It was allegedly a one-woman corporate shell, seemingly resurrected for a very specific and highly questionable purpose. The sheer control Lively allegedly exerted over this entity, serving multiple executive roles, underscored the personal nature of the lawsuit and fueled speculation about its underlying motivations. The revelation of her direct involvement painted a stark picture of strategic and personal engagement in the unfolding legal drama.
Finally now have learned what this so-called case was that everyone's wondering, where did this come from? It was from a case from Vans & Inc. versus John Doe's 1-10.
The web of connections tightened further with the discovery that Ryan Reynolds, Blake's husband, was also intrinsically linked to this ghost company. Public records revealed that his home address astonishingly matched the one listed for Vans & Inc. in court documents. This wasn't merely a coincidence. It explicitly tied the Deadpool star directly to the heart of this shadowy legal operation, raising immediate questions about his knowledge and involvement. Why would his personal residence be listed for a company allegedly used as a front for such a controversial legal strategy? This connection added another layer of intrigue and complexity, demonstrating that the scope of this alleged manipulation extended far beyond a single individual and directly into the celebrity couple's shared world, intensifying the scrutiny on their collective actions and motives in this escalating legal battle.
More people did their due diligence to figure out, well, who's this Van Zandt? As we sorted word out, learned out that was a company of Blake Lively.
Adding to the controversy, Vans & Inc. wasn't a newly formed entity for a pressing legal issue. It had been completely inactive for a staggering 11 years. No products, no services, no discernible purpose, until it suddenly crawled out of the legal graveyard to serve as a tactical dog for Blake Lively's alleged revenge campaign. This extended dormancy, followed by an abrupt resurrection for a highly specific lawsuit, screamed manipulation rather than legitimate corporate activity. Legal experts were quick to point out the extreme rarity and suspicious nature of reactivating such a company solely for a lawsuit, especially one so devoid of identity. The inactive history highlighted the alleged opportunistic nature of its revival, fueling accusations that it was merely a convenient vessel for an ulterior motive, a legal zombie brought to life for a single, targeted mission.
It was owned by Blake Reynolds, her married name, as the chief CEO, secretary, financial officer, etc. So it has now been confirmed that yes, this Van Zandt versus the John Does is clearly a Blake Lively lawsuit, but clearly was filed without anybody's actual
The lawsuit itself was a masterpiece of vagueness, accusing nameless, faceless individuals of violating corporate loyalty laws without ever specifying what they did when they did it, or even who they were. It was likened to suing the heir itself, a legal document so hollow and bereft of identifiable facts that its primary function appeared to be obfuscation rather than seeking justice. This deliberate lack of detail, combined with the absence of named defendants, strongly indicated that the lawsuit was never intended to proceed to trial or win on its merits. Its emptiness served a singular, more insidious purpose, which would soon become chillingly clear. The lawsuit's inherent lack of substance made its actual power all the more disturbing, revealing a strategic choice to operate in the shadows of legal ambiguity.
Lawyer will tell you you do not file a complaint if you don't know the name of the person that you are suing, unless you're trying to protect that person's identity for some reason, which if you're pissed off enough to sue them, you probably don't care about.
The real and allegedly cynical point of Vans and Inc. was not to win a case against John Does, but to exploit a crucial legal loophole. It granted Blake's team subpoena power. With this power, they could legally demand confidential documents and communications from third parties, regardless of the lawsuit's lack of merit. This was allegedly a side door break-in dressed up in courtroom drag, meticulously crafted to circumvent conventional discovery processes and gain access to highly sensitive information. The entire flimsy facade of the lawsuit hinged on this one sneaky detail, revealing a calculated strategy to leverage judicial authority without the inconvenience of a genuine legal dispute. The true target was never the John Does, but the confidential data they could compel someone else to surrender, unveiling the core manipulative intent behind the entire operation.
Now I have questions, because as we have both Brian Friedman and Lively's lawyers have sort of commented on this, Brian Friedman told the Daily Mail, this appears to be an end around, skirting the process to be able to secretly get these documents without having to give.
The specific target of this newly acquired subpoena power was Stephanie Jones, Justin Baldoni's former public relations representative. Jones had worked with Baldoni until August 2024, only to be hit with a subpoena in October 2024, ostensibly from the Vans and Inc. case. What followed was a stunning display of compliance. Jones reportedly handed over messages, emails, and other confidential dirt without objection or even attempting to notify her former client. This swift and unquestioning surrender of sensitive materials immediately raised eyebrows, suggesting a level of cooperation that went far beyond mere legal obligation. Her willingness to provide such damaging information against Baldoni ignited a firestorm of speculation about her motives and the underlying dynamics at play in this increasingly murky legal saga, turning her into a central figure in the unfolding drama.
This company has been inactive for 11 years. And Blake Reynolds is the CEO. When I saw this, I was like, how can we connect Vans and Inc. to Ryan Reynolds and Blake Lively? How do we know that they're the owners of?
Further deepening the controversy, the subpoena was remarkably narrow in its scope. It targeted only one phone belonging to a woman named Jennifer Al, a colleague of Stephanie Jones. If the goal was to uncover comprehensive evidence of corporate disloyalty, one would expect a wider net, subpoenaing multiple individuals within the firm. Instead, the focus was laser sharp, appearing to be a sniper mode operation, zeroing in on a single source of information. This highly specific targeting strongly implied prior knowledge of what could be found on that particular device, reinforcing suspicions that this was a targeted information extraction rather than a broad investigative effort. Such precision in the subpoena process further underscored the alleged premeditated nature of the entire legal gambit, raising serious questions about the ethical boundaries being tested.
Ryan Reynolds on public records is the same address as Vans and Inc. In the court documents. Also, these court documents are filed by the same lawyers and the company that represents Blake Lively and Ryan Reynolds in their lawsuit against Justin Baldoni.
Then came the bombshell revelation of a glaring conflict of interest. Stephanie Jones is married to Jason Hewitts, a senior partner at WME, the powerful talent agency that represents both Ryan Reynolds and Blake Lively. This marriage link created an undeniable and deeply problematic connection between the two sides of the legal battle. It appeared to create a direct pipeline for confidential information from Baldoni's former PR to Lively's legal camp, bypassing all ethical firewalls. Such a direct familial tie to a key player in the opposing camp immediately fueled speculation that Jones's actions were not merely coincidental or legally compelled, but potentially influenced by her husband's professional allegiance. The disclosure of this marriage intensified accusations of a deeply unethical manipulation, suggesting a blurring of lines that Hollywood talent agencies strictly advise against.
Public information. And the thing is, there's no other explanation for how Stephanie Jones could be subpoenaed. So someone here is saying that this is called a straw lawsuit, and it's common in celebrity lawsuits and ironically smear.
Insiders began to speculate wildly about Stephanie Jones's motivations for her alleged actions. Theories range from a desire for revenge, perhaps feeling salty that Baldoni had left her company, to a calculated move to impress powerful Hollywood elites at WME, including her husband. Another possibility was a strategic maneuver to take down Jennifer Ahl, whose phone was specifically targeted. Regardless of the exact motive, the prevailing theory was that Jones had access to sensitive materials and, instead of upholding her professional obligations, allegedly whispered to Blake's team, "Hey Blake, wanna ruin some careers?" This narrative suggested a deliberate and active role in providing the crucial dirt, transforming her from a passive subpoena recipient into a potentially key enabler of the alleged campaign.
Stephanie Jones knew this and was not involved in any of this. She would have fought it.
Blake Lively, according to the allegations, did not hesitate to weaponize this newly acquired information. The moment she reportedly got wind of the potential for damaging messages, she allegedly reactivated her dormant zombie company Vans & Inc., filed the fake lawsuit, and secured the subpoena. This entire chain of events was reportedly executed with speed and precision, designed to have everything hand-delivered like Uber Eats, but for legal chaos. This depiction paints a picture of a calculated celebrity using every available resource, no matter how ethically questionable, to achieve her objectives. The speed with which the alleged plan unfolded further underscored its premeditated nature, suggesting a readiness to deploy such tactics the instant an opportunity presented itself, demonstrating a ruthless efficiency in leveraging legal instruments for personal gain.
As I said before, why didn't they subpoena more people in Stephanie Jones' company? There was more people involved with Justin Baldoni. I mean, Stephanie Jones was also working.
The timing of these events was anything but coincidental. The Vans & Inc. lawsuit mysteriously vanished, dropped from court dockets, just one day before Blake Lively officially filed her much larger CRD complaint on December 20th, 2020. This perfectly timed disappearance revealed the alleged true purpose of the ghost lawsuit. It was a fake-out move to grab confidential data, serve its shady purpose, and then vanish like it never existed. The moment the subpoenaed information was harvested, the company was discarded like an overused Hollywood prop. This strategic timing left little doubt among observers that the initial lawsuit was merely a legal fishing expedition, designed to secure evidence for the main event, before being summarily canceled once its utility expired.
There's a lot of really sketchy stuff going on.
Legal experts universally condemned this alleged tactic, flat out calling Vans & Inc. a straw lawsuit, a case filed with zero genuine intention of winning, existing purely to manipulate the legal process. This isn't just bending the rules, it's a textbook example of abusive process, an offense that carries serious ethical and professional repercussions. The very definition of a straw lawsuit highlights its deceptive nature, as it uses the veneer of legitimacy to achieve an illicit outcome. Experts stress that such filings undermine the integrity of the judicial system, reducing it to a tool for personal vendettas, rather than a forum for genuine disputes. The expert consensus confirmed that Blake's team was allegedly navigating a dangerous ethical minefield, gambling with their professional reputations.
The cell phone records from Jennifer Abel, they said they got a subpoena, which also allowed the New York Times to...
The entire alleged scheme was a blatant attempt to sidestep a fundamental ethical and legal obligation, Stephanie Jones's non-disclosure agreement with Justin Baldoni. Jones was explicitly prohibited from handing over confidential texts and emails, but Blake's team allegedly saw a loophole. By hitting her with a subpoena from their fake lawsuit, they could create a legal compulsion for her to comply, thus seemingly absolving her of NDA violations. This wasn't clever lawyering. It was allegedly a transparent, ethically dubious strategy to force the surrender of protected information. The deliberate use of the subpoena to bypass a direct contractual obligation exposed the manipulative core of the operation, revealing a willingness to exploit legal procedures to gain an unfair advantage at the expense of established agreements.
This is not over in any sense of the word. I think there's a lot of there's going to be a lot of questions asked by the Banat folks who signed.
Perhaps the most insulting and legally problematic aspect of this entire alleged charade was that Justin Baldoni was never notified that his private communications were being subpoenaed. Not a letter, not an email, not a single courtesy heads up. This is not just poor form, it's explicitly illegal in California, where civil code demands that the person affected by such a subpoena be promptly informed. Blake's team allegedly simply shrugged and said, "Nah, we'll skip that part," treating legal requirements as optional. This egregious omission constituted legal pickpocketing, denying Baldoni his fundamental right to challenge the subpoena or protect his privacy. The blatant disregard for notification requirements underscored the alleged intent to operate entirely in the shadows, leaving the target completely unaware until it was too late.
Inc., an active, possibly inactive company, is used as a front and has no active relationship with anyone in this scenario, is used to harass and intimidate third parties for discovery.
The New York Times, an esteemed journalistic institution, found itself unwittingly caught in the crosshairs of this alleged manipulation. They published an article citing the subpoenaed information, totally unaware that they were reportedly being played like puppets by Blake Lively's team. Had the Times known how the material was gathered through an allegedly fake lawsuit and illegal means, they likely would never have touched it. This wasn't journalism, it was reportedly gossip with a lawyer's business card stapled to it, where a reputable news outlet became an unwitting conduit for a targeted smear campaign. The Times' role, however unintentional, highlighted the sophisticated nature of the alleged operation, demonstrating how even established media could be exploited to legitimize illicitly obtained information and shape a public narrative.
I believe in self-help in the current lawsuit that is in the New York District.
Blake's team allegedly didn't just leak raw information, they performed a master class in defamation by design. They meticulously handpicked, curated, and carefully edited every bit of the subpoenaed material, stripping out context, deleting explanations, and eliminating any semblance of balanced portrayal. The goal was singular, to make Baldoni look like the devil in a cardigan, turning innocent texts into potent weapons. This wasn't about revealing truth, it was about constructing a narrative, ensuring that every piece of information served to damage his reputation. The strategic alteration and presentation of the material revealed a chilling intent to fabricate a public image, demonstrating a sophisticated understanding of media manipulation and the power of selective storytelling to achieve a desired damaging outcome.
Because the date, just 4 days after the filing, they issued the subpoena to Stephanie Jones, who willingly did it because Stephanie Jones had an axe to grind.
The New York Times article featuring the selectively leaked messages dropped like a nuke almost immediately after the subpoenaed information landed. This wasn't a slow news cycle, it was a preloaded PR bomb, perfectly timed and dropped on schedule, ensuring maximum impact. Within just 3 months, the public witnessed a rapid escalation from a fake lawsuit to a suspicious subpoena, culminating in a full-blown public takedown. This precision timing removed any doubt that the events were sloppy or accidental. Instead, it painted a clear picture of a highly coordinated, strategically engineered campaign designed for optimal reputational damage. The synchronized release of the article cemented the perception of a targeted and deliberate media strike, tightly integrated with the alleged legal maneuvers.
Anything they can do to use their power to shut up and intimidate and get control of Justin Baldoni, it sure looks like that's what Blake...
Yep.
Karma is now raising her hand, as legal experts are circling this case like hawks. Allegedly using a sham lawsuit to issue subpoenas and manipulate court documents isn't just bending the rules, it's flirting with the forfeiture of a law license. This isn't merely a rookie mistake, it's textbook abusive process, and Blake's entire legal team could be staring down the barrel of serious state bar investigations. The gravity of these accusations suggests potential professional misconduct that could lead to severe penalties, including disqualification from the current case and formal complaints against their professional standing. The legal system designed for justice does not tolerate such alleged blatant manipulation, signaling that the consequences for such tactics could be far-reaching and career-ending for those involved.
There's been a lot of talk about Stephanie Jones, the publicist behind Jones' work, the one that gave out all the information from her co-worker's phone, and all those text messages and emails ended up, as we know, in the New York.
Brian Friedman, Justin Baldoni's relentless attorney, is now playing 4D chess, vowing to untangle this entire nightmarish web. He publicly stated that Blake's team's actions appear to be an end-around skirting the legal process, a polite legal translation for "you cheated and broke the system." Friedman's intention to take all action allowable under the law signals an aggressive legal counterattack, directly targeting the alleged impropriety of the Vans and Inc. case. His statement indicated a deep understanding of the alleged procedural misconduct and a firm resolve to hold Blake's legal team accountable for their tactics. This legal showdown is set to scrutinize every aspect of the alleged manipulation, promising a fierce battle for justice and accountability in the courtroom.
Fish for information that's off limit or out of scope. Damage reputations, and it's extremely
The fallout for Blake Lively and her legal team could be devastating. If a judge rules that Vans and Inc. was in fact a straw lawsuit created solely to dig up dirt, Blake's entire stack of evidence obtained through that subpoena could be tossed out like last season's influencer merch. Without those materials, her CRD complaint risks looking less like a serious legal claim and more like a desperate PR stunt. Even worse, her team could face civil sanctions, fines, penalties, and public embarrassment. If the firm is proven to have knowingly filed a fake case, they could be disqualified from representing her entirely, potentially facing bar complaints and severe damage to their professional reputations. This isn't just losing a case, it's an imminent reputational bloodbath, threatening to scorch her carefully curated image.
Speculating how was there a subpoena there if there was no legal implications at that?
This isn't merely about a lawsuit anymore, it's a full-on credibility war. Blake Lively, who has spent years polishing a flawless, untouchable public image, is now poised to step into a courtroom with that perfect persona shattered across headlines. The alleged sequence of events, from resurrecting a dead company to filing a phantom lawsuit, issuing a shady subpoena, erasing the case, launching an official CRD complaint, and orchestrating a reputation-crushing New York Times piece, all unfolded in under 4 months. This military-style legal ambush was precise, calculated, and engineered to perfection. The meltdown isn't approaching, it's already underway, playing out for the world to see, as accountability demands a reckoning that no carefully curated Instagram post can deflect.